On to the next appeal.
The next appeal we'll take up this morning is the appeal of Southern Oil of Louisiana LLC versus Esther Sarah Taylor and the Plaquemines Parish Board of Review, docket number 23-220-75003 through 008.
I see you identify yourselves.
Ellen Dunbar on behalf of the Plaquemines Parish Assessor Sarah Taylor.
Richard Lee for Southern Oil.
Sarah Taylor, Assessor of Plaquemines Parish.
Mr. Hoffman.
Chairman, as we talked about, there is a written objection that was submitted by the assessor's office in connection with certain exhibits the taxpayer pre-filed. We need to take the objection up first. It's Ms. Dunbar's objection, so she can go first, make her argument, allow the taxpayer's attorney to respond.
Okay, Ms. Dunbar.
Sure. We have objected in this case based on a statute I know you all are familiar with. It's Louisiana Revised Statute 47, 1989, C2A1, which basically provides that the review of the correctness of an assessment is limited to the review of evidence that has been presented to the assessor prior to the close of the deadline for filing a complaint with the Board of Review. And here, the Plaquemines Parish Board of Review hearing for 2023 was held on September 28th of that year. So the deadline for filing a complaint with the Board of Review was September 21st. Exhibits 14-1 through 28, as well as an unnumbered exhibit. It's labeled NSAI SOLA, and it's dated July 12th, 2024. So over a year after we were well into the 2024 tax year at that point when that was provided. But all of those exhibits that are dated past the September 21st, 2023 deadline, we are objecting to and asking that the commission exclude. And again, the purpose of this statute was because there were some situations in the past years where certain taxpayers there's a deadline to file a LAT form. It's a self-reporting process, and LAT forms are due on April 1st of the tax year. And what was happening was that several taxpayers were filing LAT forms to meet the deadline, but the LAT forms were bare bones and had no meat to them. And so then later on, information would trickle in whenever it was convenient for them to provide it, sometimes before open books, sometimes after open books, sometimes during the appeals process. And so the assessors were not receiving all of the information that they needed with the LAT form in order to provide an accurate and correct valuation. So the legislature passed this statute a couple of years ago to set a firm deadline by which evidence should be submitted in order for this commission to consider it during an appeal hearing. So that's why we're arguing any evidence that was submitted after that September 21st date should be excluded. And just for the sake of not, and we've been here a long time, for the sake of not going back and forth this morning, I would just like to briefly address some of the arguments that the taxpayer has made in opposition to our objection. Essentially, the taxpayer has offered the statute provides that it is within your discretion if you find that there is good cause or good reason why a taxpayer did not timely submit evidence, that it could be provided to the assessor and she can consider it and adjust her valuation. So in their opposition to my objection, they essentially addressed four main reasons of why they think good cause exists for the late submission. The first two I can address very quickly. One of their arguments is that Pritchard and Abbott's website was down for a period of time, and I guess they weren't able to access information that they needed. Exhibit 5, these are taxpayer exhibits. Taxpayer Exhibit 5 is an email where Mr. Carricker, who is their tax representative, he does inquire about the inability to log on to Pritchard and Abbott's website. That email is on August 1st, 2023. And the very next day, on August 2nd, 2023, they replied and said the issue had been resolved. So it was resolved within a day, and that was over a month before any evidence needed to be provided. So I don't find that to be a significant event. Another argument they make is that Pritchard and Abbott had an internal staff change, which is correct. There was an employee, his name was Mason, I can't recall his last name. He was working on Southern Oil's information and was working with Mr. Carricker, and he did leave the company at some point, and it was the file was transferred to Mr. Mize, who you will hear from later today. Exhibit 14-1 is the information that the taxpayer claims was sent to Mr. Mason and lost in a rabbit hole when he left and not provided to Mr. Mize. But that information wasn't even sent until October 17th. And if you recall, I stated earlier that the deadline to submit any information was September 23rd. So if there was a period of time where there was a staff change, the information was still submitted already a month past the deadline. And that's confirmed by Taxpayer Exhibit 17, where on October 26th, just a few days later, Mr. Carricker forwards that information to Mr. Mize, the new employee who's handling the file. And he says, this is attached as the additional information I received from Southern Oil. So again, he's forwarding information that was first provided to the assessor's office on October 17th, and we're already past the deadline. The other two reasons that they present in their opposition for why this late evidence should be submitted is kind of this overall theme that the assessor's office told them or other taxpayers that they were going to work with taxpayers during the 2023 tax year because there was a change in the rules. And again, there was. For the 2023 tax year, the rules for assessing oil and gas properties under Chapter 9, they were new, and so the procedure to be followed was a little bit different. But it affected every oil and gas taxpayer across the board. And notably, there are no other oil and gas appeals, or at least for Plaquemines Parish, that involve taxpayers who were not able to meet the legal deadline for providing information to the assessor. And more importantly, each time Mr. Carricker asked the assessor's office about whether he could submit late evidence, the assessor's office firmly replied that the books were closed and the roll was final. Exhibit 3 is a March 23 email where Mr. Carricker asks about the deadline to submit a LAT form, and he acknowledges that the assessor's office did not give any extensions. Exhibit 4, the assessor's office has to reach out to Southern Oil and say, we haven't gotten your LAT form. Mr. Carricker acknowledges, I'm working on it, but I had to get to Lincoln, Claiborne, DeSoto, and Jackson parishes first. So unfortunately, for whatever reason, Plaquemines was just not a priority. Exhibit 7 is a September 23 email, September 5th. So this is 2 weeks before the deadline to submit information. Mr. Carricker asks if he can still send information to Pritchard and Abbott. He doesn't even mention Southern Oil specifically. It's just a general question whether they're accepting late information. And the assessor's office replies, quote, at this point, we consider the tax roll to be final. Exhibit 8 is a September 6th email from Mr. Carricker to Pritchard and Abbott, where he acknowledges that he talked to the assessor's office and she indicated that officially the books were closed. But if there was additional information, the assessor might consider it to see if it was significant. That email also didn't even reference Southern Oil specifically. So there was no indication or agreement by the assessor that all of the legal deadlines in place could somehow be ignored. And then lastly, there seems to be an argument that because the assessor has continued to work with Southern Oil and consider information, that those communications or submissions should somehow be allowed, and I would respectfully submit that that argument should be rejected as well. The Plaquemines Parish Assessor's Office is always willing to work with taxpayers before and after a Board of Review hearing and leading up to a tax commission hearing in an attempt to amicably resolve or settle, if you will, the issues on appeal so that both sides can avoid the time and expenses that are associated with an appeal like this. But the assessor's willingness to try to resolve appeals is not a willingness to throw any legal deadlines out of the window or to waive any rights to object to late submissions. And this understanding is evident in Taxpayer Exhibit 16, which is an October 26th email from Mr. Carricker to Mr. Mize. So we're after the deadline has passed, we're in October. And Mr. Carricker asks about the status of Pritchard and Abbott's review of the information because he states if they can't, quote, resolve their issues, he's gonna need to file an appeal. On Exhibit 21, we're in January now, January of 2024. Mr. Carricker emails the assessor's office, again, seeking to see if, quote, we can settle the appeals at the tax commission. And then lastly, Exhibit 25 is a February 24th email where Mr. Carricker emails the assessor's office again asking if there are any revised values, stating, quote, "Hopefully, if I can show them just the totals, they'll make up their mind and decide to accept or move forward." Importantly, the assessor's office responds and says, quote, "Attached are the original 2023 tax roll values for Southern Oil. No changes have been made yet to any values," which confirms the understanding that these were settlement discussions. And that, again, the assessor's always willing to look at information you'll provide to see if we can resolve it. But that is not an agreement to allow that information to be introduced as evidence if we get to the point where we're unable to resolve it and have to actually come to an appeal. And then the last thing I'll state is the crux of their appeal evidence is the July 12th, 2024 exhibit from NSAI SOLA. It's a valuation report. It was not provided until just a few months ago in July of 2024, over a year and a half after LAT forms are due in April of 2023. And there hasn't been any kind of adequate reason why that report is provided late. Yes, the statute does say if evidence wasn't available to a taxpayer, you might find that good cause exists to allow it in, but there's a difference between it being available and them not getting it. All of the information that was provided in that July report, they could have prepared much earlier than that time frame, and for whatever reason I'm unaware of, it just wasn't done. So it's not that it wasn't available, they just didn't take it upon themselves to timely ask for it or present it to the assessor. And so for that reason, again, what I'm asking for is any exhibits, particularly 14-1 through 28 and the NSAI SOLA report that are all dated past the September 21st, 2023 deadline, be excluded as evidence in this appeal for noncompliance with Louisiana Statute 47-1989.
Thank you. Mr. Lee?
I would point out that she's referred to in her argument a bunch of the exhibits for reasons, explanations, but left out, well, for example, I'm sorry, the fact that she wants to cut it off at September 28th. Well, that's exactly, I think it's on September 7th, when it's found out that Mr. Patterson, whom Mr. Carricker was dealing with, had left. And he just doesn't respond. Mr. Carricker is willing to testify, and I can have him come up here and testify to say that he sent this information to Mr. Patterson and got no response, timely, before September 28th, actually, and got no response. So he's looking, as she said, in the exhibits that we're offering, he's looking to say, well, what happened? What happened to Mr., what's the deal with the answer? It isn't until October 19th that he gets a response from Mr. Patterson saying, I don't work there anymore. I don't work at Pitcher and Abbott. So there's a time when he thinks he's submitted this information and Patterson has it, but then doesn't work there anymore. So he, according to the reason for these emails is he contacts the lady at the appraiser's office, Marin, that's dealing with this, and she says, on October 20th, deal with Mr. Mize. Deal with Mr. Mize at Pitcher and Abbott for the information. So he resends the information. The information goes to Mr. Mize. And that's when the information, the discussion goes on. And Mr. Carricker says, well, he's worried because he's got to make his appeal to the Louisiana Tax Commission. So he does, he appeals here, and they do continue to discuss matters. The reason for this shows that there was an ongoing discussion. Now, the information that they used is information that was provided well before all this. So it appears in their material, which we will be going over. There was another time, I think there's two times, when the Pritchard Abbott website has problems. There's also a problem with working interest. The information that came from the appraisers, the assessments that came from Pritchard Abbott had the wrong working interest information. And as you're all aware, this was a new year, and there was a problem somewhat with the definition of what was working interest versus I think expenses and net revenue. So all that had to be changed because their records were wrong. And we'll show you, if you look at their own Exhibit C, you'll see that they issued their information appraisal assessment on one of these wells that was absolutely wrong and had to be changed. They said 48 million. It's one of the wells we'll talk about. And they had to change it to 38 million. So yes, a lot was going on. And that's what the reason for this is, just to show you, the reason for these exhibits is so that the panel can see that there was information, there was discussion going on, information was being provided. Can't provide it, or can't help it if they send it to Richard Abbott and the guy's gone, he doesn't work there, and he gets no response. He doesn't say, we don't have your information, and nobody says, sorry, we can't consider that. Just a month later, they say, oh, doesn't work. I'm sorry, he doesn't work here anymore. So and that comes from Mr. Patterson, by the way. So there is, he's not even asked to talk to Mr. Myers until October, actually, I think it's October the 20th. So there's nobody he could deal with. He goes to the assessor, says, I understand you're dealing through Pitcher and Abbott, that's your representative, but there's nobody there. The guy's gone. I need to contact somebody there. So it is until October 26th, actually. And actually, Mr. Myers responds and says in one of the exhibits, Exhibit 16, Mr. Myers says, Marin, the lady at the assessor's office, told him if there was a major issue, they would consider changes, but anything minor would be unlikely to get a change. Well, that's fine. We're going to talk about a major issue. These are serious issues that were going on. I mean, we're talking about a well that went from is 35 million, and then in 24 it becomes 8 million. There's a serious issue as to the approach that the assessor's office took, and that's what is trying to be explained to them. They ran this thing out for 24 years when that's not a reasonable application for the assessment of them. So that's why all those exhibits were admitted. Now, as to the expert reports, the evaluation by Mr. Beglin, the statute is very clear. I'll read you the section concerning it says nothing in this, and this is, I'm reading from now 2A, triple I, and eventually BB. Nothing in this item shall be construed to limit the liability of the Louisiana Tax Commission to find good reason to admit otherwise admissible evidence or evidence pursuant to the subparagraph double B consists of documents and records of income and expense concerning the valuation of oil and gas property, and the taxpayer has timely provided all information required by rule, and the documents or records are supplement to that submission. That's exactly what happened. By the way, the July 12th date is the case management order. The case management order said, have that in by July 12th. It was in by July 12th. That's the expert. Now, they didn't hire him until May. Of course, it wasn't available earlier if they didn't have it till May. He provided it. It was submitted. It was received. We checked this morning, by the way. It was received by the assessor. They objected to it. On July the 12th, they did meet the rule as to when that information had to be submitted. If necessary, I'd like to call Mr. Carricker and he can explain those exhibits.
I just have a question. So y'all emailed Richard and Abbott before the deadline. Didn't hear anything back from him. Deadline came and went. Then you emailed them again to ask him,
What
hey,
happened?
what happened?
And then
Is that an accurate
that is
reflection
a
of what
very
happened?
accurate, that's what exhibits show. That's
Okay.
what the email showed.
Can I comment on that? Can I address that? The exhibit that Mr. Leaf is referring to, when he says there was a September 17th email, which was 4 days before the deadline, it's taxpayer exhibit number 11. Mr. Carricker does email Mr. Mason Patterson and says, can you send me the appraisals for Southern Oil in Plaquemines Parish? It is not an email submitting information. It has several attachments on that email. It's submitting information for Texas Petroleum, about 6 different reports for Texas Petroleum, because this wasn't an email specific to Southern Oil. It was an email specific to all of the different properties that Mr. Carricker works on for Plaquemines Parish. Did he ask Mason to provide appraisals for Southern Oil? Yes. Was this 4 days before the deadline to submit anything to the Board of Review? Yes. Did he provide any actual information for Southern Oil that just got lost in the black hole because Mason left? No. The first email after the LAT form that ever provided any information for the assessor's office to consider for Southern Oil was not until October 17th, which is Taxpayer Exhibit 14-1. And there he sends a lot of information, production charts, reserves and economics reports, several attachments, 8, 9, 10 bullet points. October 17th. So it's disingenuous to argue that information was sent to Mason prior to the deadline and there just was not a response received. It looks like Mr. Carricker waited until Sunday, September 17th, 4 days before the Board of Review to even start working on it.
Questions by the commission?
I have one, Mr. Chairman. Can you clarify to me what actually took place on October 19th? That was mentioned in your
October.
presentation. And
These passed an email back to Mr. Carricker, say he didn't work with Richard Nabby.
Right. So on October 17th is when Mr. Carricker finally submitted some information to Pritchard and Abbott. And 3 days later, on October 20th, is when Mason said, I don't work there anymore. So there was not this extensive time lapse where they couldn't get anything done. And again, the point is that all of this happened after the deadline. For whatever reason, I don't know if it's internal or external, this just wasn't given priority. And one of Mr. Carricker's emails admits that when he says, I worked on all these other parishes, I haven't gotten to you yet.
and update me again on September 28th. Tell me what transpired from your office on that date.
September 28th would have been the Board of Review, so the deadline was September 21st. And from our records, the best we can tell, Mason did not leave Pritchard and Abbott until September 26th. So he didn't leave until the deadline had passed.
But he sent it before the deadline came and went, and he didn't do anything by the deadline.
He did not, if there is an exhibit that shows information was submitted, I would like to see it, or I would like
That's what
Mr.
we'd like to
Carricker
see.
to
Is
point
there
it out.
any
That's what I
record-
would like to see too.
Is there any record of any document, any email prior to the deadline to Pritchard and Abbott saying, hey, what's going on? Where's my stuff? Anybody?
Testify.
For the record, my name is Ken Carricker. I'm with Affiliated Tax Consultants, and I'm the property tax consultant for Southern Oil Company. One thing that I would dispute when it's argued that I did not provide any information until up in October, that's not quite factual because we provided initial information to the parish, which was eventually passed on to to Pritchard and Abbott in our LAT filings with the DCF form. We also provided lease operating expenses. We provided average price, the prior year average price, which was required, and we provided the working interest, revenue interest, since the DCF form required that. I think Richard has indicated that we had issues with them having to go back and correct those working interests. So there's communications back and forth. And as far as talking about this ongoing situation, once we found out that Mason wasn't there anymore, Andrew Mize with Pritchard Abbott got back with me. After I had contacted him, he said, sorry for the delayed response, was not expecting to have to wrap up Mason's stuff as well this year. He said, do you have the most recent information you sent to Mason that I can take a look at? I'm sorry, this is Exhibit 16. I apologize. Andrew Mai says, I just talked to Duran at Plaquemines and she said if there were major issues, that they would consider changes, but anything minor would be unlikely to get a change at this time. Well, when you're talking about the difference between almost $40 million in value and approximately $8 million in value, that is significant. And then
When did that conversation take place? Was it
this was
after
on
the
Octo-
deadline
this
for
was on,
submittal?
I had emailed him on, originally, when I found out that Mason wasn't there, I emailed him on October the 20th.
So after the deadline? okay.
Yes, but I would throw in also that there were times that I had been trying to get a hold of Mason and was not getting any response from him.
Do you have
until-
emails that y'all submitted that show that?
I'd have to go back and search through them. here
No,
real
do you
quick.
have emails that you submitted to this already that we would have proof of that?
Let's see. Let me get off of that here a minute.
Okay, while we wait, any questions from the commission? Do I?
Those
do-
emails.
Yeah,
I'll just make a comment. Throughout 2023 and 2024, well into 2024, the assessor's office and Pritchard and Abbott, we did attempt to amicably resolve the issues so that we didn't have to be here. The information that was consistently provided was unreliable and inconsistent. Just as a most basic example of the inconsistency, one of the properties that's under appeal requested a fair market value from the Board of Review for over 10 million. But when the LTC appeal was filed, the requested value was reduced to 5.3. So the information was just inconsistent throughout the entire.
That's because a LAT form was filed timely to meet a deadline, but there was nothing submitted with it. And then when they began working on it and started getting their act together and gathering information, the numbers changed. It
Okay.
it
okay.
flows.
Okay, let's hold up. I think we're ready to hear a motion on this objection by the assessor. Do I hear a motion from the commission?
That's why I said there were two issues. There's the emails that Mr. Carricker had, which are the numbered exhibits. There's also the fourth extra different. And that's one you should talk about.
The motion is an objection to the documents that were submitted after the deadline. That's what the motion we have before us today.
But the experts wasn't submitted. That was submitted at July the 12th, which was the deadline for his.
Chairman, the taxpayers council's point is these arguments are different with regard to the exhibits. So you are within your discretion to consider certain exhibits or not consider other ones. But the chair can entertain a motion. The exhibits at issue are 14-1 through 28 and the unlabeled exhibit NSAI SOLA.
I assume y'all objecting to all,
Yeah, I don't understand how, I just don't understand the argument that the report filed on July 2024, why would that have a different deadline than any of the other evidence that was due before the Board of Review
Because it's July 12th was the actual date.
of this year, of 20?
of this year? That you had to submit to the assessor prior to.
The Louisiana, the statute that my objections are filed under, 47-1989, when it goes through the exceptions to allow late evidence, it does say expert reports can be submitted late if they were requested or ordered prior to the deadline for the Board of Review. So even expert reports are still due prior to the deadline of the Board of Review, or the assessor doesn't have the benefit of having that information when she has to prepare her tax roll.
Well, but that's different than the expert that appear here. The case management order says, in the section I was reading was not that one. That's if you're trying to say something that addressed the Board of Review. This is for this tax period, for tax court and the tax commission. And the date for that was July the 12th, which we met. It was submitted to that. It just, in the statute says if the things are just submissions that supplement his testimony, then that's fine. It says that point blank, and not the section she's reading, section I read. There's it's okay if it consists of documents or records or income or expenses concerning the valuation of oil and gas property when the taxpayer has timely provided all information required by rule, which is July the 12th, and the documents or records was supplemental to the submission. That's what it is. That's what they are. That's what this. Thanks,
Report ordered.
in May of 24. It was ordered for this, so he could come here and talk to you.
Chairman, I'll just point out that the statute does contemplate that good reason will be presumed for reports or appraisals prepared by an expert if the appraisal or the report was ordered prior to the deadline for presenting evidence, or prior to the deadline for filing an appeal with the Board of Review. Y'all dealt with that issue in Phillips 66 recently. It sounds to me like this is an expert or an appraisal that was ordered after the deadline. But the taxpayer's attorney is correct. If it's simply documents to supplement other submissions, there is a separate subsection that deals with that issue.
So are we being asked to accept the appraisal that was ordered after the fact or the documents? Because I'm unclear.
The assessors objected to the entirety of the exhibits that were not timely presented to her office before the deadline for filing with the Board of Review. The taxpayer's attorney is suggesting that there's independent arguments. Certain exhibits should be considered simply because there's a good reason, but the taxpayer's attorney is arguing there are other exhibits that would fall under one of these subsections where good reason should be presumed.
From the commission.
Hearing none, do I hear a motion?
Mr. Chair, I'm gonna make a motion to exclude the exhibits that weren't timely filed.
Do we have a motion? Is there any discussion on the motion? We have a motion. Is there any discussion from the commission? Is there any objection? Hearing none, motion is adopted. We rule in favor of the assessor on this one.
Call Mr. Beglin, Mike Beglin. And we proffer those exhibits.
Sure, Chairman, you can accept the exhibits under a proffer.
And just so we clear, not implying anything, let's not try to slip the exhibits into the discussion and stuff. We just ruled we're not gonna consider them. So I just want to be very clear. Let's not play the game of it.
Got the same stuff.
Not implying anything, but let's stick to what we can talk about.
Yes. Mr. Beglin, we ready? Mr. Beglin, can you tell us your educational background?
Yes, I have a bachelor's degree in chemical engineering from Ohio State University, and I attended LSU in graduate school in petroleum engineering for 2 years.
And where have you worked?
After graduate school, I went to work for Exxon in New Orleans as a petroleum reservoir engineer, and I worked there for 8 years. And then I moved to Dallas and went to work for my current company, Netherland and Sewell, in 1993.
What does Netherland Sewell do?
So Netherland and Sewell was formed in 1961 by Clarence Netherland to evaluate oil and gas properties, reserves, and value for oil and gas companies and financial institutions.
And what companies do y'all represent?
We have represented companies domestically, internationally. We do work for Exxon, BP, Conoco, Concho, most of the Haynesville operators, companies internationally, Pemex. Our firm is well-known internationally and domestic at doing this type of work.
Okay, what have you done while you worked there?
I have handled numerous resource play accounts. I've handled other accounts during my time there. including various Louisiana properties over the years.
Have you been testified as an expert in courts?
Yes, during my time at Exxon, I testified at the Alabama Oil and Gas Board. During my time at Netherland and Sewell, I have testified in federal court in Shreveport and in Wichita, Kansas as an expert.
And is this the type of work that you do all every day?
Yes, so evaluating oil and gas properties is what I've done for the past 40 years at Exxon and Netherland and Sewell.
Okay. And did you, over the years, have you been familiar with what is now the Southern Oil wells that are in the Blackman's Parish?
Yes, our company has done reserve evaluations at each year end for Southern and their predecessor companies for about the last 20 years. None of that was for these types of purposes. That work is done for their internal company purposes, accounting purposes, and then the last few years for Securities and Exchange Commission's filings.
Ask you if, Pam, if you could bring up the Assessor's Exhibit C. Sorry. Okay, if you go to page 5. Yes, ma'am. It's hard to see, but up in the top left-hand corner, what particular well is that addressing?
Yeah, so this is the state lease 17675 #1 well.
And are you familiar with this information? Is this where this comes from?
Yes, so this is accounting data from Southern.
Okay, so this information is now appearing in their exhibit, in the assessor's exhibit. Do you have any issue with this, the information, that it's incorrect or anything?
No, we have no issue with the information.
Okay. If you go to page, now this should be a little confusing, 7. I believe this is that same well, and what is this for?
So that is the lat form that Southern filed with their valuation for this well.
Okay, if you go down to the bottom. Their valuation was 8,900,000.
Yes, that's the number on the form.
Okay, and if you go to page 9. Page 9, it's their exhibit, and I'm not complaining, but page 7 and 9 actually go together, I believe. What is page 7, page 9?
Yeah, so this is the new discounted cash flow approach that's being used this year for the 2022 values. And this is the numerical results in that form.
Okay. Now, let's go to back to page 8, and then just for clarification, the form that was submitted by Southern Oil was 7 and 9. For some reason, the parish's form here on page 8 in between. You recognize this? Have you?
Yes, I have
Have
seen
you
this
reviewed this?
before. Yes, I have reviewed this.
Okay, and go down to the bottom, please. And if you look at the bottom down here, it says their value is 48,710,000. This is what they have submitted. That's not actually correct.
No, this one was done incorrectly using 100% working interest instead of the royalty interest. And that seems to have been a common misapplication at the time. It was later revised by Pritchard and Abbott.
The 38.
And a $35 million value instead.
Let's go to the next page, I think. Go down, another page, another page. Okay. And what is this?
So this is an oil and gas production plot. The oil volumes each month are shown in green. The gas volumes are shown in red. The triangles are the actual data. The line is the forecast of what production this will make in the future per the Pritchard and Abbott evaluation.
Now, when Pritchard and Abbott evaluated this particular well, how do you understand that they applied with the information that shows on page 8 and this page 10?
Yeah, so their engineering analysis technique to make this forecast was to use a simple decline analysis. And a decline analysis is intended to fit the historical data with how is that production falling over time? And is it fast, slow? And numerically, it can be from 0 to 90-something%. In this case, they applied a 10% decline, which is considered very shallow. The production does not drop very fast, and you can see that on this plot. The result of that was that this well has a 24-year remaining life
By their interpretation?
by their interpretation. It's produced from this reservoir since 2010 already. So it's already produced for 12 years at the point of this 2023 tax evaluation. It had already produced over 1 million barrels of oil at that time. Their estimate indicates that it will produce more than double that going forward still at another 1.7 million barrels. And so it will ultimately produce almost 3 million barrels, which would make it the third best well ever in the Breton Sound.
And have you evaluated this well?
So as part of our year-end reserves evaluations, we evaluate this well each year. We use a different technique to do that evaluation.
What is that?
And so in this case, we map the reservoir. We use seismic data. We use log data from the wells that penetrate this reservoir. We make a map of how big we think this oil accumulation is. So if you think of this accumulation just as a big tank underground, that's one way to view it. And so is it a big tank, a medium tank, a little tank? We can use data to get some sense of how big this tank is. And then we take that data and calculate what we think this will be able to recover. And so our forecast each year has been based on that estimate. And it's different, and it results in a much shorter life than the 24-year remaining life that this forecast
What was your
gets to.
valuation? What was your value?
Our evaluation for the year-end reserves analysis was a 2.5 year life.
And why is that? Well, dollar-wise, what did that come out to?
We had a value around $6 million.
Okay, why is that? Why do you think?
I want to just object and note for the record that while they're not referencing a specific excluded exhibit, the testimony we're hearing is essentially the same commentary, and it's based on an excluded exhibit. He's just testifying live as to the information we previously excluded.
Testifying from there.
So these reservoirs produce under a mechanism. These reservoirs produce under a mechanism known as water drive. And so in a water drive scenario, you can envision the oil sits on top of water, basically. And there's a volume of oil, and then there's a volume of water below that. And as you produce the oil, the pressure drops and the water moves, and it pushes the oil forward. And the reason that oil production looks fairly constant up there for a long period of time is it has water behind it pushing the oil out. And so you can maintain a constant production rate. At some point in time, that water reaches the well. And when it reaches the well is gone in the next 6 months, 12 months, very short time. Nothing like 24-year period.
What's your opinion on what the industry standard is?
Yeah, so the industry standard approach would be to use the mapping data to come up with a volume. Now that requires having data from the operator. So you need the seismic data, you need the log data, and it takes time. In lieu of not having that, one would typically apply, like in this case, that rate's been very constant for the last year or so. So you might say that rate will continue to be constant for 1 year, 2 years, and then you would put it on a much steeper decline, recognizing that these wells don't last. You know, it's been on for 15 years. It's got a 24-year remaining life in their evaluation. These wells don't last for 40 years. They just don't. That's not a South Louisiana oil well. That's a resource play well that lasts that long.
Is there another well in there? Same type of,
Yes, yes. The state lease 17860 #2 was a similar situation. Those are the two main wells that constitute what I see as the biggest issue in assigning value to these properties. And so that well, again, is another water drive well. In our evaluations, we do volumetrics. We use that as our volume. In this case, a 8% decline was used on that well, and it has a 28-year remaining, 8% by Pritchard and Abbott, and it has a 28-year remaining life. It's already produced since 2014, so that would put it at almost a 40-year total life also. It's just unrealistic.
I appreciate, excuse me, I appreciate the explanation, but I want to clarify again that we're going to hear the testimony, but if it goes beyond the materials timely submitted to the assessor, or it's comments responding to the appraisal prepared by Abbott and Richard, we are not going to consider it in it. So we walking a fine line right here of getting to it. So let's stick to what's objected was objected. We're not going to listen to it. Stick to what's relative to what you can talk about, because we're getting very close to, we're talking about stuff that we just excluded.
So I guess I'm a little confused. I'm just giving my expert opinion as to their analysis. And I cannot do that?
no, instead you're hearing.
Yes, yes, yes.
I have a question. When did you perform your analysis of this well?
Well, we analyze this well every year end. So we've done it multiple times. For this purpose, we were hired in May of 2024. And that's the evaluation that's
So
been
you've done this
excluded
well before?
numerous times.
Okay.
Yeah, every
What
year.
was your projection in 2023?
That
you-
was the. Yes. Yes, so we had our volumetric estimate on it at that time. We had a 2-year remaining life at that time. It is still on now. It has exceeded the volumetric estimate. So we now use the technique to extend it for 1 or 2 years flat and then put it on a 50% decline.
Your projection of 2 years was wrong.
Yes, it continued to produce, yes.
What was the 24 assessment on this one? Like, did they consider the oil driven?
The Pritchard and Abbott assessment for the 2024 tax year, yes, they revised their forecast to address that it was a water drive reservoir. They had a much shorter life. They used a shallow decline for several years and then put it on a steep decline after that.
I would just note for the record, I object to any discussion about the 2024 assessment because on January 1st, 2023, when the property is assessed, you don't have the benefit of knowing the actual information of what's going to be happening in the future.
Stick to 2023. Let's not go to 24.
Hello, members of the commission. My name's Andrew Mize. I work for Pritchard and Abbott. I'm actually the director of mineral appraisals there. I have a petroleum engineering degree from Texas A&M University, and I've been working in the property tax field for oil and gas for around 15 years. As has been stated earlier, we had an employee working these wells. We have multiple employees in our company working oil and gas well appraisals for a number of parishes. We had a particular employee here that got the initial lat form information and came up with this initial appraisal. I'm just going to kind of talk about the new discounted cash flow methodology that came into effect in 2023 for a second. In previous years, all oil and gas wells were valued using the cost approach, and there was just commission tables that were derived based on depth and an area where the well was. And that was pretty much how the value was. And it was just, you file the depth and you file where it is, and the tables kind of come up with the value. There was some discussion about obsolescence, and that's what ultimately led to us switching to this discounted cash flow income approach. So this lat form, I'm mainly going to talk about the well that they just presented up there from the exhibit C, because that's the main one, the main point of contention here. So the discounted cash flow analysis is an accepted method of valuing oil and gas property. We've used it in Texas since the 20s. And there we do it for interest. This is for the actual well itself. And it's all based on what buyers and sellers would pay for that well as an economic asset, as opposed to the cost to make it. And the way we're doing that, as opposed to, say, a traditional income approach where you do a direct capitalization of a normalized income stream, say for an apartment complex or something like that, is because the product being produced is almost always on a constant decline. You're actually looking on your as of date and saying what is going to happen with that income going forward, and we're going to discount the estimate of that income back to our present value. So if you want to pull up that Exhibit C, page 7, which was the lat form, and kind of walk through some of those parameters that we're requesting. Page 7. And I'll come back up to those other. So this is the new lat form required for the DCF methodology for this specific well. And it requires several parameters when you're talking about an oil and gas appraisal. Doing the discounted cash flow, the income is made up of the oil and gas and any other kind of petroleum products that are produced from that property. And so you're looking at that. That's the product being made or produced. And then you also have the price of those commodities. All of this information up top is identifying the property. One thing they talked about was that net revenue interest. The rules and regs in Chapter 9 that were changed in Chapter 2023 specified that we can only consider income for the well that's going directly to the working interest. So that number right there is supposed to represent the share of revenue that goes only to the working interest owner. On this lat form they filed it is 0.625. So basically a little over 60% of the overall revenue from the oil and gas product being produced from the property going to them. This is only a one well property. That some of these properties can have multiple wells involved because we're looking at the LU code production. The lease unit well production is identified by the Louisiana Department of Energy Resources. And so that identifies the property, the share of the operator's interest. That's going to determine what share of revenue we're looking at. Then we start going down to the next part of the section, the oil production forecast. This is looking at where that production is at on January 1 of 2020. We're talking about 2023. Sorry, we're 2 years backwards. So they put in the form what their selection was for that January 1 production date. And then those next lines in both the gas and oil section are their projection of decline. Now they talked about how this well is showing that steady state decline, that 10% decline. They filed on this lat form a 30% decline from January 1 to the first year, and then a 25% decline from there, and a 20% decline from there. That was not borne out by history, and there was no supporting documents with the lat form to support that decline scenario. I'll point out later some sections of the lat form that can point out limited life or limited reservoir volume that are part of this form that can be filled out. So that's the main reason for our difference in value right there. Those 30, 25, 20% decline profiles, that was not borne out by the history. As you can see, I don't know which page it is. It should be page right here. Yeah, we're talking about that actual production. It does not show that line that goes through the production does not show that 30, 20%, 30, 25, 20% decline scenario. It's a step scenario saying the first year it's going to decline this much, and then it's going to decline this much, and then it's going to decline this much. So that's the production forecast, and that's really our main difference. We go down through the next sections where Chapter 9 says you have to use the previous year's price received from the property. They filed 9607 and 636 for the gas, and when I look on our appraisal, our input was 9181 for the price and 692. So we're a little different on the prices there. Those may be our default prices if we didn't have a filing lat form from an operator. Like I said, I was not the original appraiser on here, so I don't know what the reasoning was for not changing that. But that can be up to the assessor. It does not just have to be taken as rote what's on this lat form as far as the discounted cash flow analysis, because there are opinions about what that income stream is going to do going forward. Just like we talked about, like they did a volumetric analysis, and there's some estimation going on about what's left. The other part in there is the tax allowance. So that's another expense item that we allow for in the discounted cash flow. So we've got our gross revenue, that's the price times the commodity that we're projecting to be produced. And then we do deduct some from that, some percentages from those prices for taxes that are paid on that production. The next line is the direct operating expense, and that's what it's costing them to continually operate this well, to continue to produce that oil and gas from the property. Yeah, right there, that direct operating expense line, the 1.425 million. We actually used 1.2 in our appraisal. And so that can be a discussion between the assessor and the taxpayer, because that's not supposed to be just the exact actual amount that they paid last year. It's supposed to be, if I'm buying this asset, what is it costing to continually operate this property? So we're just looking for the recurring costs, and additionally in those lines, any kind of future capital expenses that might be incurred to maintain this production level, this production decline level. So if you go down to that bottom line, the optional limitations for DCF, these are actually input lines that can be used by the taxpayer, where they talked about the volumetric analysis, to put a limit on remaining reserves. Barrels would be your oil, gas would be your MCFs. And you can also, one that we see sometimes is the max years of the discounted cash flow. So if you have a scenario where we're talking about here, where we do see the assessor's looking at the production, we had a 10% decline, and we're forecasting a long year's life, if there's a reason that we need to consider a shorter life due to volumetric calculations that, quite honestly, the assessor doesn't have access to, like they stated, that's going to be operator information, and information, quite frankly, that would be helpful filed with that operating expense information. Like the volumetric analysis would be something to include with the lat form, or an estimated of ultimate reserves would be something to include in the lat form when filed. That would justify going to that number, because water production and volumetric analysis and all that is not something the assessor has access to. It's not something that was even stated in here. The only thing that was stated on the lat form was a decline scenario that was not proven by the historical production decline itself. You can see they proposed an $8.9 million value. If you go to page, is it 8? 8, yeah. So you can see we had the 100% working interest. I had discussions with Ken later, and we switched that number to where it was not 100%. I do not know why it was left at 100%. But this is the original appraisal that we submitted to them. So that was really the only consideration I had until July when we got the NSAI information about the water issues. Was a conversation about the decimal interest. And I do agree that I don't know why we're at 100% there on that value. Like I said, I didn't do this original appraisal. So, but there was a difference in what I was provided later on between that lat form and what was stated. They stated a 0.625% interest in this well on the lat form. And then later I was told it was a 0.77 interest. So there was some confusion there as well. If you scroll down to the bottom of this page, you can see we are projecting 24 years of remaining economic life. There's all our price information, operating expense information. And the year's life is really, it's a result of the cash flow stream. And because in the normal course of the cash flow, the remaining year's life is cut off when there is a negative cash flow to the operator in a future year. That didn't happen here because it's producing, like they said, it's producing at such a high rate and such a low decline rate that it just let that cash flow continue to run. And so that's the reason that there is such a difference there. It's a difference between that remaining reserves number because all the assessor has to work with Chapter 9 is what is provided on the lat form and what they can see from public information if it's not provided by the taxpayer. And so when we're looking at the public DNER production data, and then as you can see, we did use information that was supplied on the lat form. This was the result of our analysis, and that's how we came up with that initial $48 million number before all these discussions began after the fact.
Mr. Chair, if I may, just to stay on this exhibit, Ms. Banks, would you scroll up? So as I understood, the lat form was filed by the taxpayer.
Correct.
They had a declining rate. That declining rate was compared by Pritchett and Abbott to the tables that were supplied, and the math didn't
Right.
match up with that usage.
Correct. And in Chapter 9, the Chapter 9 rules, in Section 907 B1, it does say production forecast to be analyzed by assessor for relevant trends and patterns established as of January 1 of the current tax year.
So this calculation here was at the 100%, as you said. This was the initial Pritchett
Correct.
and Abbott.
After reviewing all the lat form information. Correct.
Okay, and it ended up, we'll get to where it ended up, or that the actual number.
That, as far as I know, like I said, there's a lot of steps in here as far as legal and timeliness of supplied information, but as far as what the assessor had prior to the September 24th date, this was all that was provided via the lat form and what we came up with as far as an initial appraisal.
Okay, thank you.
Can I ask, Mr. Mize, do you understand this to be a water-driven well?
I do now.
And what, do you understand how that works?
Yes, I do.
Well, tell me, how does that normally apply?
Well, the water is essentially driving the oil and gas products towards your wells. And eventually you will get, what will happen is you have a constant production rate. And then eventually that water will hit the well. Now, there's a lot of discussion about when that's going to hit. I mean, and y'all even stated that it's actually produced past your initial projection. So is 28 years how long it should be? If I was looking at it and I knew that it was a water drive, I would have a different opinion about it, but I did not have that information. And from a pure assessment standpoint, if all we're looking at is production, historical production and decline projections, and there's no mention of any kind of volumetric analysis, we have to go with the baseline assumption of what historical decline has been because there was no statement of the property being a water drive property until much later.
Have you worked with Breton Sound wells before?
I have not until recently.
isn't well known in the industry that Breton Sound is water-driven wells?
It could be, and like I said, I did not work this original appraisal.
So you don't know if. Mr.
I do not what
Patterson
was
knew
going
about it?
through this is the employee's head doing this appraisal.
So, so you wouldn't dispute the fact that Breton Sound wells are generally water-driven?
No.
Or that it will end suddenly? And
Could.
Brian, correct?
Potentially.
And, you don't necessarily now think that it would last 28 more years? Your opinion?
It was,
If answering that question involves information you were not privy to prior to September 23, I do not answer it. I object to that question.
I object to the question.
That's all I have. He follows instructions well.
So, Mr. Chair, one more question. So as a point of clarification, going back up to that lat form, and you mentioned, I think, that there was an opportunity for the taxpayer to present something. Ms. Banks, could you scroll up, please? Scroll other way. Right there. So the optional limitations for DCF. Excuse me, I think that's where you were mentioning that the taxpayer can disclose information on the lat form relative to additional limitations in the calculation, which I assume would indicate the life. That's your assumption, that that's where they would indicate something there.
Correct.
That's where it can be provided. And I guess from the taxpayer standpoint, it assumed that this was known to be a water well, so it didn't have to be disclosed that there would be optional limitations?
Mr. Mize, if you did have the general knowledge that it was a water well, would that have been enough for you to be able to fill in the blanks on that form, or would you still have needed them to self-report that information to you?
If I had general knowledge at the time of making this appraisal, I would take that into consideration. If I did not, then I would needed them to provide some supplement or additional information in this lat form to clarify that.
Additional questions by the commission?
Can I ask him about what she just asked you? You say, did you seek to find out if there was an oil well, a water-driven well at the time?
There were multiple properties involved in this discussion, and it was never, I spent most of my time trying to clarify which properties we were actually talking about until much later in the process when we finally got down to geologic aspects of the property. There were issues with identifying the properties in general, so no, I did not.
So you would admit that it makes a big difference in the valuation, the market value of the well?
It could if it was known, yes.
Is it your duty also to the taxpayer to be reasonable about application?
I object to him speaking on what his legal duty is owed to the taxpayer. It's a self-reporting process. The way it works is the taxpayer reports the information to the assessor who uses it to value the property. It's not required by the assessor to seek out information or ask specific questions or information from the taxpayer.
He's not going to answer that question.
I don't think so. Okay.
So, Mr. Chair, just as a point of clarification, there are 4 assessments that are being appealed today. I assume that the methodology and the lat forms and the declining rates and such, whatever we're seeing here in this exhibit is a component of one of the assessments and the other three are identical in theory? Or are different arguments on each one?
This argument, or this particular well, was the one that had the most substantial difference. However, we were not made aware of any issues until July of '24, which is our issue. So I can go back to this assessment that this particular well is on is assessment C 600510, and the original assessed value is 8479275. The other assessments are a bit smaller. And actually, now that we're talking about it, let me make a note that 48 million in 2023, the tax commission rules implemented a cap. So this 8.4 million assessed value is not reflective of the 48 million fair market value. The assessed value versus on a 48 million would be significantly higher than 8.4. So no, the other assessments do not have substantial changes,
There was, I think,
and none of which were discussed prior to September 21st, 2021.
and Mr. Begman did testify about another well that had the similar problem.
Do you want to make a different argument on the other wells? I think is what Mr. Romick is asking. Same argument.
It's the same argument. It's the same, it's water driven. They ran it out for a long period of time.
Thank you.
Any question from the any more comments from the attorneys? Questions from the commission?
I have a quick question. I just want to make sure my briefing sheet's updated. What values are y'all asking for on?
Do you want the total assessed value for each assessment? Oh, yes, okay. Yeah, so C 599424, the original assessed value is 1814975. C 620035, the original assessed value is 1814976. C 771236 is 665598. And then the final one, C 600510, the original assessed value is 8479275.
Thank you.
Any more questions by the commission?
Yeah, I'm sorry, I'm confused by those numbers. So the briefing sheet, just for instance, 599424. So perhaps you're giving what we have on a briefing sheet, fair market value is $12,075,060.
I can pull that up. I'm giving assessed value.
Okay.
Yes.
And the taxpayer's value is in comparison to the assessed value.
Taxpayer
Yes,
submitted
yes,
fair market value,
yes.
their opinion of fair market value.
Yes.
Okay. There was a lot of work on this, so I just want to make sure I'm giving the right information. That's, okay. Market value yeah. Let me compare it. Yep. So 4437, this is 771. Yeah, because this would be before the January. Mhm. For the actual assessment. I think that they're on that. So. I just want to I want to make sure. 599 1209. Yeah.